Good afternoon, everybody. I'm Hylton. We're here with Steve as well. We're both barristers from Park Lane Plowden Chambers who specialise in personal injury and clinical negligence work. And I think it's fair to say, have a particular interest in fatal accidents claims. We've actually done two similar sessions already, Steve and I. In the first, we looked at a case called Ricks, and in the second, we looked at a case called Head. Both of them were fatal claims, but in the context of family businesses. And we were talking about issues to do with things like lost years and the difference between income derived from profit earning chattels as opposed to income derived from somebody's labour and skill. To complete the trilogy, we're going to talk about a case which we call Witham, but officially is called Steve Hill Limited and Sarah Witham. That's a case from the Court of Appeal, and it was a decision delivered in August 2021. The plan for the next 30 minutes or so is to split the session into two parts. In the first part, I'm going to do the talking for about 15 minutes, and I'm going to start by explaining the background to the case to set the scene, and then dealing with the first of three fairly interesting issues that arise from the claim. In the second part, Steve's going to talk for another circa 15 minutes about the second and third fairly interesting issues that arise from the claim. And at the end of all of that, if anybody has any questions that they want to put on the chat, we'll do our best to try and answer them. So without further ado, let's move on to part one and my bit, where I'll start by explaining what the case of Witham was about. So the claimant in this case, who was Sarah Witham, worked as a specialist paediatric nurse. And in 2003, she married the deceased. In 2015, having not had any of their own biological children, they decided to start fostering two children who were known as Child A and B in the claim. Child A had autism and ADHD, and Child B had ADHD and an attachment disorder. In 2018, those fostering placements were made permanent, but a year later, in 2019, the deceased died from mesothelioma caused by asbestos exposure whilst working for the defendant company, who was the appellant in the case. The claimant's claim was brought, not unsurprisingly, under the Law Reform Act and the Fatal Accidents Act. Liability and most things were not in issue. The issue in the case was really about the service's dependency claim or claims. That was all arising from and connected to the fact that in the family, it was the deceased who'd remained at home providing childcare and other domestic services so that the claimant, Sarah Witham, could go to work. At first instance, in the High Court, before Anthony Metzer QC sitting as a High Court judge, he made various official findings of fact in relation to the children being fostered not as a result of any kind of sinister or proper business decision or choice to maximise the family's finances, but as a decision made by a loving couple without biological children. And he acknowledged that the plan all along was for the claimant Sarah Witham to continue going to work while the deceased stayed at home. In the case in relation to the litigation, the judge at first instance found that the dependency in this particular case was that of the claimants as opposed to either of the children. He actually said that the children had not suffered a loss because the care had been replaced by the claimant. He said, therefore, it was the claimant who was dependent on the deceased and not the children. And it was that which allowed her to pursue her career for the benefit of the whole family. And as a consequence of his death, she'd effectively lost her career. And he called that a, quote, family loss, which you could measure by reference, if you wanted, to her lost income. However, on the question of valuing that dependency, he decided not to value it by reference to the claimant's actual predicted lost earnings or pension loss, because he said that was, quote, not within the ambit of Section 3 of the Fatal Accidents Act. Instead, he said the appropriate measure was the value of the replacement care provided at, importantly, the commercial cost. In the end, he assessed the claimant's damages at £928,000, and £666,000 of that was attributable to the lost services referable to the two children. On appeal, in the Court of Appeal, there is a nicely lengthy judgment, it's fair to say, which goes over all the basics and serves as a useful reminder to the Court of Appeal and us, of course, what these cases are about. So there's reference to cases like Wood and Bentle, Caper McLaughlin, Burgess and Florence, and it sets out the basic principles, which are: you can bring a claim like this where there is a reasonable expectation of a pecuniary advantage from the continuation of somebody's life. There is no prescribed method for bringing that claim. The only requirement is that it's capable of being quantified. And the court really has to do whatever it can with the material available, which best fits the facts of a particular case to determine the loss. And it's in that case, in that context, that the Court of Appeal really focused on three particular things, which is going to form the rest of the structure of this session. The first was about the introduction of some new evidence and some new circumstances which arose between the date of the first instance decision and the appeal. That's the bit I'm going to focus on in a second. The second thing which the Court of Appeal's decision focuses on, which is important, is about the nature and the principles that underline the basis of the loss suffered. That's the first thing that Steve's going to talk about. And the third was about how you go about actually quantifying that loss. And that's the second thing that Steve's going to talk about. So they're the three main things that the Court of Appeal had to make decisions on. And they're the three things that we're going to talk about now. So the first one on the list, which is what I'm going to talk about, is what you could call a change in circumstances. This is what in the judgment they referred to as ground 5. It was actually, as an aside, only added as a ground of appeal after the appellant had already achieved permission to appeal. Their argument, for reasons which I'll explain in a minute, is that the original decision was erroneous in light of events this trial. And in particular, it had transpired that children A and B were no longer in the claimant's care. Now, the situation looks a little vague in the judgment. It sounds like the claimant seems to have had her own personal difficulties. That appears to have culminated in some sort of meeting between the fostering team and the claimant's general practitioner. Doesn't sound like the claimant was altogether happy with the situation, because she'd raised issues about a lack of support from social care, and she said that some of her issues had been misinterpreted as her having an inability to provide care. And it's even true that at the time of the appeal, she had a complaint made to the council, which was not decided. But as a matter of fact, at the time of the appeal hearing, the children were not in her care. She hadn't seen them for about a year, and she had no knowledge whatsoever of their whereabouts. So what the defendant, now the appellant in the appeal, wanted to do is say, well, this is new, this is a change in circumstances, and it has to affect the outcome of the decision in the case. Now, so some of you might know about the case of Ladd and Marshall. That's often referred to when we talk about new evidence. The two cases that this judgment particularly relies on and refers to is one case from 1960 called Bull and Thomas, and another from 1971 called Mulholland and Mitchell. And what those two cases together basically say is that fresh evidence ought not to be admitted where it was within the field of uncertainty that the original trial judge made an estimation of. But fresh evidence may be permitted to be admitted where to refuse that application would be an affront to either common sense or a sense of justice. Now, in this case, as you can imagine, the claimant in the claim, the respondent on the appeal, argued that the defendant at first instance hadn't tried to cross-examine the claimant about the issue and hadn't made any submissions at trial about the likelihood of fostering not working. But what the Court of Appeal said is, whilst it's right the point wasn't taken at trial, at the time there was no grounds or basis for any questions or submissions along those lines. As such, at trial, it was kind of not even identified as an area of uncertainty for the trial judge to make an estimation of. In any event, they said, actually the most that could have been achieved would have been some sort of modest reduction to the multiplier. What's actually happened is of a wholly different nature, and in effect, the factual basis of the dependency claim as was no longer exists. And bottom line, they said to refuse this would be an affront to common sense or a sense of justice. Now, far be it from me, and I'm definitely not arrogant enough to say the Court of Appeal got it wrong. I'm sure they're right. But I think it's fair to say that when you first read the judgment, the decision is a little bit surprising to people who do practice in the area of fatal accidents. I can definitely, from my perspective, see the common sense justice point. However, as per decisions like Welsh Ambulance and Williams, it's a sort of fundamental principle of these sorts of cases that the dependency claim and loss is fixed at the moment of death. And what decisions people make and generally what happens subsequently is supposed to be irrelevant. It's only really supposed to be factored in as part of the assessment when you think about future losses in the ordinary way. And I'm not entirely sure I see the difference between this sort of change in circumstances and any other sort of change in circumstances, like where one of the dependent dies or children leave home sooner than was originally anticipated. I suppose the argument would be, well, those kinds of things are factored in as part of the actuarial approach, or at least an implied part of the judge's assessment of future uncertainty. But in this case, I suppose, bottom line, the defendant kind of profited from not having run the argument in the first place. It made it entirely new on appeal. I wonder what the situation would have been if the defendant had raised it as an area of uncertainty at first instance and the judge had made an estimation of it. In other words, if it had been priced in to the original judgment. And I also wonder what happens if the claimant, as a result of her complaint, is successful in getting the children back. But either way, I think the practical point for us is going forwards, it might be that defendants keep an eye on claimants who've recovered significant amounts as a result of services or financial dependency claims, where there is a possibility of the fundamental basis of the claim disappearing in the future. And it might, if you're being very clever as a claimant, be prudent to invite the judge to make an assessment of that uncertainty at trial to help you if the situation does change and the defendant makes an application or an appeal because of fresh evidence. But at the end of all of that, the decision in the Court of Appeal was to admit that fresh evidence and remit the matter back to the trial judge for a re-evaluation of the service's dependency loss. But obviously the judge couldn't do that in isolation and had to take into account the Court of Appeal's decision on the other issues, hour number 2 and hour number 3, which I'm going to hand over to Steve for, and he's going to talk you through.
Okay, as Hylton said, I'm going to talk a little bit about the nature of loss in this case and in fatal accident claims, only briefly, and then a brief discussion also on the question of the rates for services dependency. The first thing probably to say about the question of loss is that this case, the facts of this case are somewhat unique, and it's a messy case, and that's why there was a discussion about the nature of the loss to start with. What I mean by that is this. As Hylton said, the 2 children in this case were adopted, and because they were adopted, they were not themselves dependents under the Fatal Accidents Act. So the children in this case did not themselves have a claim for a services dependency. And that informed the way in which the claim was put by the claimant. And the other aspect that was a little messy is that what the claimant was trying to claim was actually her future loss of earnings, because the situation would have been that the deceased husband would have stayed at home to look after the children and she would have gone out to work full time. So she claimed as her primary claim the measure of her loss as loss of earnings, and as a secondary, it was the cost of childcare. But the simple and practical point to draw from this is, putting all of that to one side, what the Court of Appeal said, which is that a surviving parent has a valid dependency claim on the childcare services that are provided by the deceased to the children. In other words, the childcare provided by the deceased to the children was a valid dependency claim as the services dependency claim to the surviving parent. What Lady Justice Nicola Davis actually said in the judgment, and this is page 43, is this: what the claimant has lost is the benefit of the service which her husband provided in caring for the children. That being so, she can legitimately claim the cost of securing those services to enable her to place herself in the position she was prior to her husband's death. So this was, in essence, as looked at by the Court of Appeal, a services dependency claim for the loss of the services gratuitously provided by the husband. And to that extent, it's almost surprising in retrospect that there was so much debate about it, because it almost seems like that's a fairly trite thing to say. It's also fair to say that the fairly unique nature of the facts probably led the judge at first instance to make some errors. For example, and Hylton had already mentioned that the judge at first instance said the judge found that the children had no loss because that had been replaced by the adopted mother, rather the fostering mother. And that clearly is wrong, because it's settled law that children who have lost a parent or someone who is looking after them do have a dependency claim. And the fact that their childcare services are provided by somebody else does not negate that claim. It's Section 4 benefit and it is disregarded. So the judge was wrong about that. And it was also unnecessary for him to consider whether or not there was a family loss, because the fact was that the surviving wife had her own services dependency claim based on the childcare. What's of a little bit more academic interest here is the discussion of the nature of the loss under the Fatal Accidents Act. In practice, we're all used to categorizing dependency claims as either a financial dependency claim or a services dependency claim, where in fact the Fatal Accident Act itself doesn't refer to services dependency claims and doesn't refer to financial dependency claims. All the Fatal Accident Act says is that damages may be awarded as are proportion to the injury resulting from the death to the dependents respectively. It's an archaic phrase because the Act has archaic origins. And as Hylton said, as he was talking about the case, the discussion of there being a reasonable expectation of pecuniary advantage is the test that the judiciary applied, the interpretation they applied to the wording in that Act, and that goes all the way back to 1863. But as time has gone by and claims have been brought, the pecuniary advantage, the reasonable expectation of pecuniary advantage that is being claimed, has been, as it were, divided into financial dependency and services dependency, and that's how we think of them today and how we claim them. As I say, in this case, the claimant was actually trying to claim as a species of dependency her loss of earnings. And so throughout the judgment of first instance, there is this reference to the loss of pecuniary advantage. And it seems like the claimant was trying to argue that the loss of pecuniary advantage was her loss of earnings, that she was going to suffer because she was now not able to go out to work to look after the children. We don't need to take that any further. because, as I say, the Court of Appeal characterised it as effectively the loss of the services dependency claim. And that brings me on to the second matter that I'm going to speak about, which is the question of rates for that services dependency claim. In that context, this case needs to be looked at as another one, and the final one so far, in a fairly long sequence of claims. Mostly, it's fair to say, at first instance, that don't go to appeal, which is perhaps why this one is particularly interesting, of the question of whether commercial rates, spinal point rates, gratuitous discounts applied to either of those two rates are applicable in the context of services dependency claim. It's a small issue in some respects, it's a narrow issue, but it makes a substantial difference, obviously, to the size of the claim that can be brought and the size of the awards that are likely to be made. And for that reason, those of us who do a lot of fatal accidents claims will know that it's a perennial battleground between the claimant and the defendant as to what rates can be applied to the services dependency. Now, on the face of things, this case is a win for claimants because the Court of Appeal endorsed the judge at first instance use of a commercial rate and endorsed his decision not to discount that commercial rate by 25% or any other discount, notwithstanding the fact that no commercial provision had actually been used, and nor was there any evidence that a commercial provision would be used. But it's worth unpicking a little bit the Court of Appeal's reasoning in this. Some of it is reasonably trite, but it's a useful restatement of the law. The first thing that the Court of Appeal said was that it was clear that the exercise that is being done here is valuing the services that the deceased would have provided had he not died. That's a useful restatement, but it's trite. The next thing they made clear was that the value of the services, the value of the claim is that of the services lost, and it's not the value of how those services are replaced. In other words, it's not whether commercial provision was used or wasn't used, or even whether the services had in fact been replaced or not. It's a question of valuing the services that the deceased would have provided. That's trite as well, and it's also in line with what is one of the leading cases on fatal accidents now, which is Williams v Welsh Ambulance, where the Court of Appeal said this, and it was Lady Justice Smith who said it, and it's something that we probably are all familiar with, we certainly should all be familiar with. She said, in respect of the dependency is fixed at the moment of death. It is what the dependents would probably have received as benefit from the deceased had the deceased not died. And this is the important bit in the context of what I'm talking about now. What decisions people make afterwards is irrelevant. The only post-death events which are relevant are those which affect the continuance of the dependency, such as the death of the dependent before trial, etc. So the point there that I want to draw is that it's the decisions that people make afterwards is irrelevant. And that decision includes whether or not to replace services and how to replace them. So it's fixed at the time of death. So far, so relatively uncontroversial, I think. What the Court of Appeal then did in the present case to look at the valuation is perhaps more of a muddying of the water. And the reasons it's more of a muddying of the waters is that the Court of Appeal, presumably because they referred to them, relied on two personal injury cases in terms of justifying the use of commercial rates and in not discounting those rates by 25% or any other deduction. The first was the case of Daly and General Steamship Navigation from 1981, and the other one was Housecroft and Burnett from 1985. Now, we may well be familiar with both of those cases from personal injury practice. But different principles apply in personal injury to fatal accident, and it doesn't help if one looks to personal injury cases to assist in an issue like this in fatal accidents, I would suggest. And the muddying of the water comes here. That is this. In endorsing the judge at first instance use of a commercial rate for the provision of services here, the Court of Appeal relied on the fact that it was reasonable to use the commercial rate where, as in this case, the survivor had given up work or lost the opportunity to work in order to provide the services. Well, that certainly makes sense in a PI context, but it's arguably a breach of the principle that one doesn't look at the facts of what has actually happened or what decisions people have made to value the services in a Fatal Accident Act claim. Because if that is right, then why isn't it also right to say the fact that someone has only provided, or rather the fact that somebody hasn't used a commercial provider to replace the services means that a basic rate is appropriate? In any event, that was the route that the Court of Appeal took to deciding the point in this case. And they even went a little further than that and said that the most that the judge might have considered it appropriate to award in this case was actually the loss of earnings, because the claimant in this case lost her opportunity to go out and work, which raises the possibility that had the judge at first instance awarded the services by reference to the loss of earnings, the Court of Appeal would have considered that was appropriate in this case. The final point that I want to make about this is that the Court of Appeal effectively then said that the judge at first instance was entitled to award the commercial rate in this case. They didn't say that he was obliged to, or as a matter of law he should do. It was simply one of those rates that was open to him to decide to apply. And so one might say that whilst this appears at first blush to be a win for the claimants, the Court of Appeal has thrown the issue back as a question of fact in all the circumstances of the case to judges at first instance. So it's still open to the defendants to argue that a basic rate is appropriate. One point that the Court of Appeal did say, which as a question of logic must be right, is that once a commercial rate has been considered to be appropriate as the measure of loss, there then isn't a jurisprudential basis in a Fatal Accidents Act claim for discounting that by 25%. And that's because it's the value of services that is being valued, and one theoretically isn't looking at how they've actually been replaced, notwithstanding the fact that, as I've explained, the Court of Appeal do seem to have looked at what happened after the death in this case to assist them with the valuation exercise. So it's a case that it's worth knowing about. It's a case that certainly you should be armed with when it comes to negotiating settlement in fatal accident claims. It probably provides more top cover for the claimant's argument about a commercial undiscounted rate than the defendants, but it isn't a definitive answer to the question of which rate should apply. And that, I think, is probably all that can really be drawn out from the case.
Well, Steve, I said we'd be 30 minutes and you stopped talking as my clock went from 29 minutes past to 30 minutes past. So I think we've timed that beautifully. But I wonder if, just to make this a little bit more interactive, it might just be worth me asking you a couple of questions, if you don't mind. Sorry to spring this on you. I think the thing I talked about was a bit unusual and isn't going to come up very often, but it's nice to know about. The stuff you were talking about is going to have a lot more practical application for people. So I think with that in mind, I've got a question about each of your 2 points. The first one about the measure of the loss. You talked about how we all claim financial dependency and services dependency, but actually the Act doesn't say anything about that. And I talked about how there's no precise mechanism. You see people pleading Fatal Accidents Act damages in any number of ways. But on services dependency claims, they often tend to say it is the services dependency claim of the surviving spouse, or they say it's the services dependency claim of the children, or a mixture of both. You know, until this point or going forward, as a practical point, what were you going to do in light of Witham when pleading these sorts of cases?
Well, I think the point to bear in mind is that Witham is authority if it's needed, that let's say that a childcare dependency claim can belong to both the surviving parent and the surviving children. In practice, not always, but in practice, the surviving parent and the surviving children will both be statutory dependents with their own right to bring dependency claims. I mean, in practice, it is more likely that it will be a surviving parent who won't be a statutory dependent than it will be that a surviving child is not a statutory dependent. They weren't statutory dependents here because they were foster children. I think I might have said adopted children at one point earlier on. That was wrong. It's foster children that puts them into the category. So it will reasonably frequently be the situation where the surviving parent is not a statutory dependent because they're a cohabitee that doesn't meet the cohabitee requirements, for example. And so the claim will undoubtedly be that of the child at that point. So far, so straightforward. In the more nuclear archetypal family, where it's a surviving parent and a surviving child who are both dependents, the short answer is you don't need to specify whose dependency claim it is. You just need to plead and claim it as a dependency claim. And in fact, there are quite good reasons for not specifying it, because it's actually a question of apportionment, really, when it comes to apportioning. And there may be family reasons why some of that apportion, some of the childcare services will be apportioned to the surviving parent, perhaps because they've provided services so far, or it might be that the parent wants all of it apportioned to the children. So I think there are good reasons for not specifying who's actually bringing the claim. It's not necessary.
Okay, and then the second thing I was going to ask you, which is about the third thing we've talked about, claiming the commercial cost as opposed to the gratuitous cost. I think I might know the answer to this one, but going forward in these sorts of cases, what are you going to claim?
Well, I'm going to claim exactly the same as I imagine that you always claim when you're for the claimant, which is an undiscounted commercial cost. I think that acting for a claimant in a fatal, you should always claim the commercial cost, not discounted. And I think that you should always specify the rate for the particular services. So there may be a different rate for a housekeeper, for a handyman, for a gardener, and for a nanny. And I think the most sophisticated way of doing it is to break down the claim and to plead whatever rate is most appropriate for the particular service that you're provided.
Okay, well, that is 30 minutes of presenting and 5 minutes of answering. So I think that probably brings us to the end of this. I should say that Kate on the chat pointed out that the handout that you've received is about, I think, litigants in person and not fatal. So somehow I think you probably received the wrong handout. So we'll make sure that's corrected. And in the not too distant future, everyone that's watching or listening should get the proper handout, which has probably everything you need to know about Witham in it. So it's a little difficult because obviously we can't see or hear you, but assuming you're still there, thank you for sticking around and listening. If anyone does have any questions about any of that, I'm sure you can get mine or Steve or both's email addresses pretty quickly from our website. Please don't hesitate to get in touch. But Steve, unless there's anything from you, I'm going to stop the recording.
No, nothing else.
End the session. Okay. Thanks, everybody.